Thank you for watching this video today. I would like to talk about an outline of the trial and appeal systems at the Japan Patent Office. From now on, I will refer to the Japan Patent Office as the JPO, and the Trial and Appeal Department as T8D. First, I will introduce an overview of the trial and appeal systems, then, an appeal against an examiner's decision of refusal, a trial for invalidation, and an opposition to grant of patent. Now, I would like to begin with an overview of the trial and appeal systems. T8D overlooks all four intellectual property types: patents, utility models, trademarks and designs. I will focus on patents in my presentation. First, let me explain what the trial and appeal systems are like. Once a patent application is filed with the JPO, an examiner examines the application. As a result of the examination, a decision of refusal or a decision to grant a patent will be issued. Please look at the pink arrow and green arrow on the left side of this slide. If an applicant is not satisfied with the result, he or she can file a request for trial and appeal. Let's move to the right side of this slide. Once a request for trial and appeal is filed, it will be examined by T8D. As you can see here, trial and appeal proceedings shall be conducted by a panel. A panel consists of 3 administrative judges or 5 administrative judges. There are 2 important points here. Review whether examinations are appropriately conducted by examiners and determine the validity of rights. I will now explain the roles and position of trial and appeal. Trial and appeal systems have 2 important roles. The first role is to review examiners' decisions. As indicated in number 1 here, the appropriateness of decisions of refusal, which are made by examiners, shall be determined. In particular, an appeal against examiner's decision of refusal system contributes to this role. As indicated in number 2 here, reliability of rights granted by examiners shall be improved under the opposition system. Results produced by examiners shall be carefully examined by administrative judges of T8D, who have advanced technical expertise. A function of the JPO is indicated in the part circled by a red dotted line. If a person is not satisfied with the decision by T8D, he or she can institute a revocation action against the decision with the Intellectual Property High Court. From here on, I will refer to the Intellectual Property High Court as the IP High Court. If not satisfied with the decision by the IP High Court, he or she can make a final appeal with the Supreme Court. The second role is to contribute to early resolution of disputes over IP rights which are granted. As shown in this slide, a trial for invalidation system contributes to this role by showing the determination on the validity of patent rights. A trial for correction system is to make correction to the scope of patent claims. A trial for rescission system is to rescind registration of trademark that has not been continuously used. The Han-Te system is known as the advisory opinion system. In the advisory opinion system, the JPO determines and publishes official opinions on the technical scope of patented invention from a fair and neutral position. Please look at the part circled by a red dotted line. This part indicates a role of the JPO. If a person is not satisfied with the decision by T8D, he or she can institute a revocation action against the decision with the IP High Court. The same is true with respect to the Supreme Court. This slide shows final disposition of cases at the JPO examination departments, the JPO T.A.D. and courts. Please look at these red rectangles on the left side. Over 200,000 patent applications are annually examined by the examination departments at the JPO. About 8,000 of those cases are annually examined by TAD at the JPO. About 30 cases are further examined by the IP High Court. Please look at the second red rectangle from left. 300 patent cases and 1,000 trademark cases are disputed between the parties. Some of these cases are further disputed at the IP High Court. Now, please look at the second red rectangle from the right. About 1,000 patent opposition cases and about 400 trademark opposition cases are annually requested. This slide is about human resource development for administrative judges at the JPO. There are currently about 2,000 examiners at the JPO. About 400 examiners with 20 years of experience are appointed as administrative judges. Some of the administrative judges have opportunities to work as judicial research official at courts for a certain time period. They support judges at the high courts by utilizing their advanced technical expertise. As mentioned in the blue sections on the right, there are also legal experts, at the JPO, who support our trial and appeal proceedings from their legal aspects. I will now explain the administrative judge panel. An administrative judge panel and administrative judges are appointed under the provisions of the Patent Act. Trial and appeal proceedings shall be conducted by a panel consisting of 3 or 5 administrative judges. One of the administrative judges shall be named as a chief administrative judge who will oversee proceedings. This slide shows the organizational structure of the JPO and TAD. The JPO has 7 departments. One of the departments is TAD, as shown in blue. TAD includes the Trial and Appeal Division and the Litigation Affairs Office. Each of these divisions is overseen by a director. Trial and appeal proceedings are conducted by boards of trial and appeal. There are 38 boards. I will explain these in detail on the next slide. This shows the Trial and Appeal Department in detail. At TAD, we have 38 boards which are divided into specialized fields. There are 33 boards for patents and utility models, 1 board for designs and 4 boards for trademarks. Administrative judges are assigned to boards based on their expertise. This table explains types of trial and appeal systems. The first column from the left classifies our trial and appeal systems into 2 categories: before or after a right is established. The second column from the left lists trial and appeal systems. If you look at the other columns, you will see check marks. They show which system is applied to which types of intellectual properties. For example, you can see that an opposition system is applied to patents and trademarks. A trial for invalidation system is applied to all 4 types: patents, utility models, designs and trademarks. In this video, I will explain the systems for the following: appeal against an examiner's decision of refusal, trial for invalidation, and opposition to registration. First, let me explain the system for an appeal against an examiner's decision of refusal. An appeal against an examiner's decision of refusal is provided in Patent Act Article 121. When a person has received an examiner's decision to refuse an application and is not satisfied with the decision, he or she can file a request for an appeal against the examiner's decision of refusal within 3 months from the date a certified copy is sent. In general, a person who is not satisfied with the administrative disposition may file a lawsuit with a district court. However, the Patent Act provides a unique appeal system which serves as a means to determine the appropriateness of examination results. First, an administrative judge panel conducts an ex officio investigation and then determines the appropriateness of a decision of refusal made by an examiner. After that, it renders an appeal decision. Let's look at an appeal against an examiner's decision of refusal flowchart. The person in the top right corner is an applicant. If an applicant is not satisfied with an examiner's decision of refusal, he or she files a request for an appeal. If an amendment is filed with the request for appeal, the applicant follows the flow on the left side. At the time of filing a request for appeal, amendment can be made to claims and description. So, amendment is often made at the same time. In this case, an examiner, who examined the application, will determine whether the decision of refusal was appropriate based on the amended description, claims or drawings. This is called reconsideration by examiner before appeal. If a decision of refusal is not appropriate anymore after the amendment has been made, a decision to grant a patent will be rendered. If the examiner still thinks the decision of refusal shall be maintained even after the amendment, a reconsideration report by examiner before appeal proceedings will be issued. If this is issued, or no amendment has been made, an administrative judge panel will conduct proceedings. First, the panel determines whether to maintain the examiner's decision of refusal. As a result of the determination, if the panel determines that the claimed invention should be granted a patent, a decision to reverse the examiner's decision will be rendered. If there is still reason for refusal even after the panel conducted proceedings, a decision to maintain the examiner's decision will be rendered. Next, I will explain proceedings on an appeal case by an administrative judge panel. In principle, procedures that were taken by examiners at the examination stage will have an effect on trial and appeal proceedings. Therefore, the panel determines the appropriateness of a decision based on procedures at examination stage. Please look at this diagram. There are 3 arrows here. The right one indicates a scenario where a panel determines that the examiner's decision is appropriate. In this scenario, the panel sends a notice of conclusion of proceedings to a demandant, and within 20 days from that, a decision maintaining an examiner's decision of refusal will be sent. The left one indicates a scenario where a panel determines that there is no reason for refusal. In other words, there is an error in the examiner's decision. In this scenario, the panel sends a notice of conclusion of proceedings to a demandant, and a decision reversing an examiner's decision of refusal will be sent. The one in the middle indicates a scenario where a panel finds new reasons for refusal which the examiner did not notify. In this scenario, the panel sends reasons for refusal to the demandant, and he or she can submit a written opinion and make amendments. The panel conducts proceedings again for the amended description, claims or drawings. If reasons for refusal are resolved, the request is granted and a decision reversing an examiner's decision of refusal will be rendered. If reasons for refusal are not resolved, the request is not granted and a decision maintaining an examiner's decision of refusal will be rendered. In practice, the most common case is the scenario in the middle. Now, let me explain the procedures after an appeal decision to maintain an examiner's decision is rendered. If the request is not granted and therefore, the demandant receives a decision maintaining an examiner's decision of refusal, the demandant can institute a revocation action against the decision. When a revocation action against the decision on appeal is instituted with the IP High Court, Commissioner of the JPO will be named as a defendant. As you can see on the left side of this diagram, a revocation action shall be instituted within 30 days after an appeal decision is sent. In response, the IP High Court determines the case and makes a court decision. If the court decides that there is an error in the JPO decision, it renders a decision to reverse the JPO decision. In such a case, TAD will conduct proceedings again. Now, I will show you statistics for appeals against examiners' decisions of refusal. TAD conducts proceedings on appeal cases and ends up notifying new reasons for refusal in many cases. In 70% of appeal decisions, which are shown in light blue and light pink, new reasons for refusal were notified. Furthermore, in 70% of requests for an appeal against the examiner's decision of refusal, the claimed inventions were granted patents. This chart indicates the ratio of revocation actions instituted against appeal decisions. Revocation actions are instituted with the IP High Court. In 2% of those who appeal against examiners' decision cases, revocation actions are instituted. I will now explain about trial for invalidation. For example, if the patent has been granted in violation of novelty or inventive step requirements, a request for a trial for patent invalidation can be filed. In the event that the patent becomes invalid by a trial for invalidation, the patent shall be deemed never to have existed in principle. Trials for invalidation are conducted by a panel by going through multiple stages. Oral proceedings are conducted at the JPO trial court during these stages. I will explain this later in my presentation. Please look at the right side. This is a trial court at the JPO. A panel sits at the front of the courtroom on the bench. Demandants and demandees sit on the sides and make allegations to the panel. Since oral proceedings are open to the public, the general public can observe and listen to the oral proceedings as shown here. This slide explains procedures for a trial for invalidation. There is a demandant in the top right of the page. Procedures begin after a demandant files a request for a trial for invalidation. A duplicate of the request is sent to a patentee. After the patentee receives the duplicate, he or she files a written reply and, if necessary, files a request for correction to make a correction to claims. After that, a panel conducts proceedings based on the written reply and the request for correction if it has been filed. In some cases, the panel gives the demandant an opportunity to file a written refutation based on the request for correction. After these procedures are taken, and issues in dispute are sorted out to a certain degree, oral proceedings are conducted. After oral proceedings, the panel determines and makes a trial decision on the case. If any party is not satisfied with the decision, the party can institute a revocation action against the JPO's decision with the IP High Court. In this case, commissioner will not be named as a defendant. The other party will be a defendant. Therefore, a patentee and a demandant will be the parties in a litigation. This slide explains how a patentee defends himself or herself and how a demandant attacks a patentee in a trial for invalidation. The demandant files a request for a trial describing reasons for invalidation. Then, the patentee defends by filing a written reply. The patentee can also file a request for correction. By making a correction to claims and descriptions, the scope of claims will be narrower. Therefore, it is possible that the patentee will successfully avoid reasons for invalidation. A patentee should consider defending himself or herself by making a correction so that all claims will not be invalidated. In some cases, the demandant is given an opportunity of rebuttal based on the request for correction by the patentee. The demandant can make a correction to a request for a trial at the same time. However, no corrections may be made which alter the substance of the written request. After some documents are exchanged between the parties, oral proceedings are conducted. Before oral proceedings are conducted, a panel sends a written notice of proceedings matters to the parties. In the notice, a provisional opinion of the panel is stated. In response to the notice, the parties file an oral proceedings statement brief in advance. The exchange of the notice and the statement brief between the parties can help smooth conducting of oral proceedings. As proceedings are conducted further, when the panel determines that the parties have fully made allegations and shown proof thoroughly, it makes a trial decision. If the decision is to invalidate the patent, an advance notice of a trial decision shall be issued before a trial decision is rendered. The patentee is given one more chance to make a correction after the advance notice. If a request for correction is filed, a demandant will be given an opportunity for counterargument. This slide explains a request for correction that is made by a patentee. A trial for correction should be made only for the following purposes: restricting the scope of claims, correcting errors or incorrect translations, clarifying ambiguous description, dissolving citation relation between the claims. Furthermore, in a trial for correction, it is prohibited to add new matters. It is also prohibited to make a correction in order to substantially enlarge or alter the scope of claims. This slide shows you the details of oral proceedings in a trial for invalidation. A trial for invalidation is examined by oral proceedings in principle because, as shown in the middle of this slide, the panel can precisely grasp and sort out issues in dispute through verbal communication between the panel and the parties. The panel can precisely understand technical issues even for a complicated case. The panel can precisely conduct proceedings at once rather than exchanging documents multiple times. The parties can fully make allegations in front of the panel. Oral proceedings are conducted expecting these effects on the outcome. As the proceedings have progressed, the parties' allegations have been fully made, and the case is ready for a trial decision. The panel makes a trial decision. A trial decision shall describe issues in dispute and determination on these issues. The panel should determine all reasons for invalidation and indicate its conclusion and concrete reasons. If anyone, i.e., a demandant, patentee or intervener, is not satisfied with a trial decision, he or she can make a revocation action against the trial decision with the IP High Court. In a revocation action against a JPO appeal decision for an appeal against an examiner's decision of refusal, Commissioner of the JPO is named as a defendant. In a revocation action against a JPO trial decision, the other party is named as a defendant. This is because a trial for invalidation has the structure of conflict between the parties. Let's move on to the system for opposition to grant of patent. This is a comparison table between opposition and trial for invalidation. The purpose of the opposition to grant of patent system is to realize stable establishment of patent rights at an early stage. The purpose of the trial for invalidation system is to resolve disputes between the parties regarding the validity of patents. Therefore, the opposition system is different from the trial for invalidation system that has a structure of conflict between the parties. Since the opposition system is ex parte, an opponent is not a party and therefore, ex parte procedures are taken between the JPO and a patentee. Furthermore, any person can file a request for opposition, but a request for opposition needs to be filed within 6 months from the date of publication of the Gazette. Let's go to the next page for more detail. In opposition to grant of patent, when a trial decision to revoke a patent becomes final, a patentee can institute a revocation action against the decision with the IP High Court. However, when a trial decision to maintain a patent becomes final, an opponent cannot institute a revocation action against the decision. Therefore, if a trial decision to maintain a patent becomes final, but the opponent is still dissatisfied with the decision, he or she will need to consider filing another request for trial for invalidation with the JPO rather than instituting a revocation action against the decision with the IP High Court. Next is how opposition procedures are carried out. Procedures are basically similar to invalidation procedures. However, there are some differences between opposition and invalidation procedures. One different point is that oral proceedings are not conducted in an opposition. Another point is that, in opposition, a duplicate is also sent to a patentee. However, there is no need to respond at this point. If a panel determines that the patent should be revoked, a notification of reasons for revocation will be issued. Then, a patentee will be given an opportunity for counterargument by filing a written opinion and a request for correction. In response to a correction, an opponent will be given an opportunity to file a written opinion. Then, a panel makes a final determination based on these documents. I will now explain requirements for opposition. The first, second and third requirements in this slide have been already explained in the previous comparison table. The fourth requirement is about reasons for opposition. What is different from a trial for invalidation is that reasons related to attribution of rights are not subject to reasons for opposition, such as violation of requirements for misappropriated applications and violation of requirements for joint applications. Let's look at the scope of proceedings for opposition next. A request for opposition to grant of patent can be made on a claim-by-claim basis. For example, if there are a total of 10 claims in the patent, but an opponent wants to revoke only the first and second claims, the opponent can file a request to oppose those 2 claims. In such a case, only those 2 claims will be determined by a panel. On the other hand, a panel can conduct ex officio proceedings. Therefore, the panel can determine those 2 claims based on reasons that are not pleaded by an opponent. For example, when a request for opposition is filed because of the lack of novelty, and a panel determines that the patent has novelty, but does not have inventive step, the panel can notify reasons for revocation ex officio based on the lack of inventive step even if reasons for opposition, filed by the opponent, is only the lack of novelty. The purpose of the opposition to grant of patent system is to realize the stable establishment of patent rights at an early stage. Considering this purpose, it is expected to make a final determination as early as possible. Therefore, only the evidence that can be very easily obtained by administrative judges will be adopted. For example, if some other evidence was already presented at a patent office in a foreign country and it can serve as good evidence, or if information is provided by a third party, the evidence can be easily obtained, therefore, it will be adopted by a panel. This slide explains notice of reasons for revocation. When a panel conducts proceedings in opposition cases, it considers all reasons and evidence. Therefore, all reasons which can constitute appropriate reasons for revocation will be notified as reasons for revocation in principle. In response to the notice of reasons for revocation, a patentee can file a written opinion and a request for correction within a designated time limit. This slide explains effects of a decision that becomes final and binding. In an opposition to grant of patent, if a decision to maintain a patent is rendered, an opponent cannot appeal against the decision. So, a decision to maintain a patent becomes final and binding when a certified copy of the decision is sent. On the other hand, if a decision to revoke a patent is rendered, a patentee can appeal against the decision with the IP High Court. A decision to revoke becomes final and binding after the time limit for filing a revocation action is expired. Or, if a revocation action is instituted with the IP High Court, a decision will become final and binding only after a case is reviewed and then a final decision is rendered by the IP High Court. If a decision to revoke the patent becomes final and binding, the patent right shall be deemed never to have existed because of effects of the decision. This effect is the same as the effect of a trial for invalidation. Lastly, I want to show you statistics for opposition to grant of patent. 6,902 requests for opposition were filed between April 2015 and December 2021. Please look at this pie chart. The light blue part indicates requests for opposition where patents were maintained with corrections. The green part indicates requests for opposition where patents were revoked. Some changes were made to more than 60% of the patents after requests for opposition were filed. It takes 8 months to complete proceedings for opposition cases. I would like to summarize today's session before closing. I have introduced and explained the trial and appeal systems of the JPO. In the first section, the roles of T.A.D. were explained in relation to examination departments and courts. As a result of examination at the JPO, a decision to refuse, or a decision to grant, registration is issued. In trials and appeals, administrative judges review the appropriateness of examiners' decisions. Or, administrative judges determine the validity of rights. In the following section, major trial and appeal systems were explained, such as an appeal against an examiner's decision of refusal, a trial for invalidation and opposition to grant of patent. Difference between a trial for invalidation and opposition to grant of patent was also introduced. I hope this video will help you further understand the JPO's trial and appeal systems. Thank you very much for your attention.